Okay, thank you. Good afternoon. Good afternoon, everyone. So let me just walk you through a quick introduction, and I'll introduce the authors, and they will take it from there. Okay. So we'll just start in another 20-30 seconds. Perfect. So guys, if you're not able to hear anything in between, if you have lost any PPT or the audio, just you have that reconnect option on the top. Just click on that and reload your page. You should be able to come join back. Perfect. Okay, so let me just give you a quick introduction about Taxman. I hope all of you are aware that Taxman is a leading publisher on tax and corporate laws in the country. We also maintain the largest and most accurate online database on income tax, international taxation, GST, company and SEBI law, IBC, FEMA, etc. Our products include books, journals, online and offline research platform, tools for TDS compliances. We are proud to say that we have developed and we have been maintaining the national website of Income Tax Department, and we have been the knowledge partners for the department's website. So quick tips for the attendees: your mic is on mute. You'll not be able to communicate during the session. You use the chat box on the right hand side. We have our entire R&D team supporting you and answering your queries through chat. At the end of the session, you'll also get a copy of this presentation for your reference. In the evening around 4 p.m., you'll also get an ebook related to this topic in your email. Right. Let me just quickly introduce the speakers. We have with us CS Gaurav Pingle and CS Rajit Sharma. CS Gaurav is an associate member of ICSI. After gaining practical, academic, and editorial experience for 8 years, he is now practicing as company secretary for the last 4 years. His areas of practice are corporate laws, corporate compliance management, SEBI listing regulations, and transaction advisory services. He has authored book on Companies Amendment Act 2017 and related party transactions. He religiously writes articles and columns on the current case laws, latest happenings in corporate laws, and articulates his views. He is visiting faculty for company law and investment and securities laws at ILS Law College, Pune. Welcome, Gaurav. Welcome to the session.
Thank you.
We also have CS Rajit Sharma. Rajit is a member of R&D team of Taxman.com. He is a company secretary and LLB having expertise in interpreting various corporate laws and interconnecting learnings across the various subjects to give a 360-degree view of the issues. He has experience in company law, IBC, competition laws, and foreign exchange laws. He has enriching industry experience of 11 years. He has contributed various articles on different subjects of IBC, corporate laws in leading newspapers and journals. Welcome, Rajit. Welcome to the session. Please walk our audience through the today's agenda and go ahead with it. Gaurav, over to you.
Yeah.
Yeah, Rachit, are you here?
Yes, I'm back. I just lost connection. Yes,
Sure.
I can hear.
Over to you. Please walk us through the agenda and go ahead with the session.
Hello everyone. Good afternoon. My name is Rachit. I'm part of Taxman R&D team, and I hope you all safe and taking good care of your health. So let's begin the today's topic for webinar, that is conducting of general through video conferencing and other audio visual means. So the whole presentation is covered into 5 parts. Part 1 is general meeting through VC or OVM and applicable provisions of the general meeting. Then the next 3 part will be relating to the introduction and applicability of Ministry of Corporate Affairs circular on AGM, and then the registration of email addresses, provision relating to it. And last, we'll discuss the key important compliance points. So friends, we know that the whole world is facing difficulties in the tough time due to COVID-19 outbreak. And in order to control the outbreak, the government has imposed nationwide lockdown and restricted the movement of persons at several places in India. So considering these difficulties by the stakeholder, the government has allowed companies to conduct their annual general meeting in this year through video conferencings and other audiovisual means. So in this regard, Ministry of Corporate Affairs had issued a circular dated 5th May, so which allowed companies to conduct their general meeting through video conferencing and OAVMs during the calendar year 2020. So subject to fulfillment of the certain conditions. So allowing the convening of the annual general meeting in these difficult times is a welcome move taken by the government and Ministry of Corporate Affairs. So the government has very well taken care of the interest of the stakeholders in defining the guidelines for the convening such general meetings. So now it has become duties of companies to follow the guidelines in true spirit to make their AGMs happen through the online system. So definitely the success of convening a meeting of the shareholders through the online mechanism would certainly create the passage of making it entering into regular provisions. This not only would be saving the cost and time of the shareholders in finding for coming and attending meetings, but it also would prove shareholders at ease in attending the meetings. So if this experiment proves to be success, the virtual AGM may be here to stay for long. But in that case, an amendment to the Companies Act may become necessary. So there are positive sides of this conducting of general meeting through through video conferencing. That is maximum participation of shareholders. It saves cost of printing and serving of annual reports, notices, rental of the venue and booking and making arrangements for the conducting of general meeting is also saved, and there are many more. So there's also a lot of persuasive logic behind holding of virtual general meeting. That is, the shareholder who cannot travel from other parts of country to the usual venue are generally forced to obtain the information secondhand, which can be both frustrating as well as disempowering. On the other side, there are disadvantages to the general meeting through video conferencing. That is, there will be lack of face-to-face communications, convenience of asking questions and seeking views would not be there. And apart from above, there are two other downsides to the virtual annual general meeting. That is, the management can cherry pick the shareholders' question they are prepared to answer, and the technical glitches could disrupt the session. And also, there's a flip side to the video conferenced AGM. That is, the minority voice can be minority shareholders' voice can be silenced. Actually, the activities who usually come up with the probing questions based on their meticulous search will be silenced by the moderator, who can potentially simply mute a dissenting shareholder from speaking, or he would just duck the difficult question on pretext of the network connection, that there is a network connection problem. So friends, with this, I hand over this session to Mr. Gaurav Pingle. He will be continuing with this session and will take us through the remaining parts. So over to you, Gauravji.
Yeah, thank you, Rachit ji, and thanks, Taxman, for the opportunity. I agree with the presentation. I will be discussing on the applicable provisions for the general meeting. Basically, for a general meeting, the provision of section 96 to section 122 of the company is applicable. I may be referring those whenever these provisions are applicable or whenever they're specifically sent to the general meeting through video conferencing. Then we also have to ensure the compliance of the secretary standards which are issued by the ICSI, because it's mandatory for a company to comply under section 118 subsection 10 to complete the secretary standard by ICSI. Also, the MC has issued circulars, and they have been sent over here with a brief summary of what it actually relates to. And it is not mentioned here, but SEBI has also issued a circular after the MCA circular has been issued, specifically in relation to the general through video conferencing. They have exempted the application of certain regulation and list regulation. So, however, it is in compliance or in consonance with the MCA circular. So that is one aspect that we need to consider in relation to the listed companies as well. So I mean, go to the particular circular now immediately, but the decision is everything in relation to circular. So I will just move on to the next slide, which relates to the introduction and applicability of MCA circulars. So when it comes to the applicability to shareholders meeting, basically the first circular that was issued, it was in relation to the extraordinary general meeting. And in the 5th May, the circular that was issued was in relation to the annual general meeting. So basically, it applies to all shareholders meeting, equity shareholders. However, there is, you can say, there is no specific clarity in relation to a particular creditors meeting or maybe a different class of stakeholder in relation to that. So it is only shareholders meeting that is considered, but fairly it covers the approval aspect for a company. Then with respect to the applicable financial year, so this shareholders meeting for the annual meeting or an extraordinary general meeting can be conducted, or an AGM can be conducted for financial ended 31st of December 2019 or 31st of March 2020, or any financial year during this particular calendar year. If all the company has the NCLT or the approval of the government, then they can have a different financial year and accordingly they can conduct the meeting. However, it should be during calendar year 2020. Coming to the applicability to companies, virtually it is applicable. Now I'm saying about the annual general meeting. It is applicable to all the companies. It is applicable to a private company, public company, unlisted or a listed public company, or a second company with capital, without share capital. However, basic provisions of general meeting or annual general meeting are applicable to one person company. This is provided in the Companies Act. Therefore, obviously, that will not be this virtual meeting will not be applicable to the OPC. However, necessary compliance under the Companies Act for OPC sufficient for the general meeting to be conducted. Now, this is one very important question, whether general meeting through video conferencing is necessary or enabling provision. Suppose there are certain family members in a private company, or it is a closely held unlisted public company, and over a period of time, considering the present scenario in India, the movement of people is allowed, or citizens is allowed in a particular area or a particular city, then can a company conduct a general meeting in person or a physical general meeting? So yes, basically the provisions, enabling provisions, it is not compulsory to have a video conferencing meeting. However, there is one clarification in one of the circulars by MCA with respect to this. However, in my view, basically, if everybody is available, and most importantly, if they comply with the orders of the or the circulars issued by the Ministry of Home Affairs with respect to a general meeting, or you can say with respect to social distancing, or all the relevant provisions of MH, then the meeting will be conducted through in person or in physical presence of the members as well. So basically, it is enabling provision. However, considering the situation of COVID-19, and specifically in relation to the social gatherings, which is a bit restricted now, it is desirable that we ensure the compliance of this particular circular, at least for the calendar year. Then there is a provision with respect to manner, mode of issue of notices to members. So this is now they have mandated that they should send it through the email ID to the email IDs of the registered shareholders. So we will come to that point, and we will discuss about its applicability to the specific companies. Yeah. So annual general meeting may be conducted through the.
Gaurav, can you take a quick break and reload the page once? Or attendees are not able to hear your voice clearly.
Okay. Now is it audible?
Can you try to reconnect once?
Oh, sir. Okay.
Yeah, guys, just give us a minute. So Mr. Gaurav will reconnect, and let's see if the voice gets better.
Yeah, audible?
Gaurav, there is some disturbance. Can you speak up again?
Yeah, so am I audible now?
This is better. Please go ahead.
Yeah, sorry, Taxman and viewers for the disturbance. This is something that we may experience even in a virtual AGM, that there could be some technical glitch. So sorry for the inconvenience caused. Yeah, so I will just discuss what was there in this circular with respect to the introduction and applicability of the MCA circulars. So is it fine, sir? Should I take this slide?
Yes, it is fine. You can go ahead.
Yeah. Yeah, for the applicability of the MCA circular, this is applicable to all the shareholders meeting, annual general meeting and extraordinary general meeting, both that it is applicable. With respect to the financial years, it is applicable to the financial year 31st of March, 31st of December 2019, 31st of March 2020, and any intermittent financial year if there is any change in the financial year that the company has obtained. Then with respect to the applicability, it is applicable to all private companies, public companies. However, it is not applicable to an OPC because they are specifically exempted under the Companies Act. There is a specific provision to that effect. With respect to the private companies, public companies, unlisted companies, listed companies, Section 8 company with capital, without capital, the provisions are applicable. Then with respect to the general meeting through VC, this is one very pertinent question for generally the professionals, that whether it is compulsory to conduct the general meeting through video conferencing, or is it a enabling provision, or is it like the companies have a meeting. So if the company is able to comply with the provisions of the Ministry of Home Affairs, the circulars with respect to social gain, and if they are able to comply with the social distancing and other health concerns, then they may have. But considering the present situation with respect to COVID, it is desirable to have a general meeting through video conferencing. However, when I say video conferencing, there are quite a few concerns that can we have it through a informal mechanism, something like a WhatsApp video call, or there was one question that was asked. So basically, it should be a secured mechanism through which the meeting can be conducted. It should be conducted through any informal way, a way in which it cannot be recorded. It is desirable that some secured system is used for conducting the meeting, because obviously it is the shareholder, it is the owner's meeting, and company needs to ensure that the necessary compliance with respect to provisions of Companies Act and MCA circular is provided. So we need to ensure that strict compliance. Yeah, so coming to the next point, it says about manner and mode of issue of notice. Yes, it can be conducted through it should be sent through email to the email IDs of registered shareholders. So company needs to take certain efforts to get the email IDs registered. This is specifically in case of large listed companies, or we will come to the next slide where there is a reference with respect to like how many email IDs are to be registered for such general meeting. Yeah. So there is this is one aspect with respect to getting the email IDs registered for the listed for the companies. In case of companies having capital, it says not who represent not less than 75% of the paid up capital. So this one aspect is about the percentage voting, and if you read the first line, it says about email address of at least half of the total number of members. So suppose if there are 10 members, then at least half of the members in number that it should be registered, and 75% in by voting rights that we have to comply. So that is specifically, this is applicable to private companies and unlisted public companies. Even the second criteria with respect to not having share capital, half of them in numbers and 75% of total voting. That this we have to ensure the compliance. Then only we can send it to the registered email IDs. If at all not done, then before the AGM is called for, the company needs to get the email ID registered. and it is always desirable so a company can always have an effective communication. For listed companies, specific criteria of numbers that they have provided, but there are quite a few listed companies who have started taking you can say necessary steps to get the email ID registered of the shareholders. So that is one aspect to the 2 points. It says about you can say the Nidhi companies that they have specifically provided. So basically this compliance we have to ensure so that we are able to send the notice annual report to the shareholders of the company. One point also we need to consider is that suppose in case of certain companies, in listed companies, we have to also comply with the provisions which are principles governing the listing regulations. So there is a specific provision about shareholders' rights and the you can say what the company has to ensure with respect to the shareholders. You can say shareholders' rights, to protect the shareholders' rights is also to be complied. Now moving on to the next slide, we will come to the important compliance points where I will be discussing the role of the company secretary or the chairman wherever it is applicable, and we will be coming to the practical points as well. This presentation that I am making is mostly from the practical perspective or mostly in an answer format that I have prepared the content. Now when it comes to the disclosure in the notice of general meeting, so the MCA circular directed that you need to make certain disclosures. So you need to mention about the frame for the general meeting through video conferencing. There is with respect to the helpline number wherever it is possible that we need to provide if at all there is any activity issue. It's something similar to the present meeting that we are having with through Taxman medium, where you can communicate to one of the persons in Taxman for if at all there is any connect issue. Just broadly an example. Then there is a provision that it should be predominantly displayed on the website of the company. So that is one aspect that we need to comply. Yes, now not be going to each and every details, but there is specific provision in the MCA circulars. Publication of notice, yes, this is also required that we need to publish the editions of the 2 newspapers, one with vernacular language and other with an English newspaper that we need to publish. There is also a provision about the contents of what you need to push in this. So there is a specific provision in the MCA circular before we publish the newspaper notice. However, there is also a provision in the rules in case of listed companies providing voting facility. So there is these 2 compliances are compliances, and companies should ensure compliance of both wherever e-voting facility is being provided. Day of the meeting, nothing changes what is provided in section 96 with respect to the annual general meeting, a day not being a national holiday. So that we need to ensure even for the general meeting video conferencing. Time for the general meeting, it is the same 6 p.m. 9 a.m. to 6 p.m. But one aspect that they have provided in the MCA circulars that we need to check the convenience of the shareholders. But this is only possible in case of certain closely held companies that you can check the convenience of all the shareholders. In case of listed companies, most of them prefer somewhere afternoon, evening, so that the shareholders are present across all time zones, subject to early morning or late night for them in the respective times they are. But there is one fact. So the purpose of mentioning this in the circular, MCA circular, is to ensure that the maximum participation of the shareholders across the world, because obviously that is one convenience which Rachit ji has already discussed in the starting of the presentation. Venue of the general meeting, this is the one very interesting question, because this has not been addressed specifically in the circular. However, there is a specific provision under the Companies Act as well as under the Secretarial Standards that we need to mention the venue of the meeting. Now, just take an example of the present webinar that we have. We don't have practically a venue for this webinar, though Taxman is situated in New Delhi and broadcast is there from New Delhi. still we don't have a meeting because none of the participants are going in the office of Taxman to attend the webinar or a video conferencing meeting. So in my view, there would not be a specific venue to the meeting. However, for the purposes of compliance under the Companies Act, the notice may mention, say for example, may mention may mention the venue of the meeting as a registered office or a different location for the purposes of the Companies Act. But practically, there would not be any shareholder who would be actually going to that particular venue and in the meeting because everything is through video conferencing. So that is possible in certain cases. But there is specific provision in the circulars, MCA circulars, the 4 circulars that they have issued. But the company needs to take a call on the venue of the meeting because to give a relevant example is that there are certain statutory registers that they are to be maintained in the general meeting. I will be taking up this point later on as well. That is possible. Now, I'm not also specifying any particular company that in certain companies they have mentioned venue, in certain companies they have not mentioned venue. So that is one legal position that we need to take at the time of issue of the notice of the meeting. Yeah, chairman of the meeting, there is a specific provision under Companies Act. In most of the articles of association, there is a provision that the chairman of the board meeting shall be the chairman of the general meeting. However, there is a specific provision that they have provided in the MCA circular of the chairman of the meeting. So that is one aspect. Generally, in case of disputes, this issue would come up before the shareholder of the annual general meeting. Now, moving on to the next slide, there is another aspect with respect to the participants in the meeting. So the participants in the meeting obviously would be the shareholders. So there would be a separate login provided by the company to the shareholders of the company. They specifically mentioned that one independent director should be present and the auditor should also be present for the meeting. There is a provision which says independent director shall attend wherever it is applicable for appointment. And with respect to the auditors also, there is a specific provision. However, I would like to refer one provision under the Companies Act because there are quite a few accountants and statutory who asked me whether is it mandatory for us to attend. In my view, desire, but under the Companies Act, there is a provision, section 46, which says that the auditor shall attend the general meeting. So it says that unless otherwise exempted by the company, then the statutory auditor shall attend the meeting, or any other person who is qualified to be the statutory auditor. So reading section 46 with the circular, in my view, the company exempts the auditor, then he may not attend. But considering that it is through video conferencing and considering the convenience, he may attend as well. This may apply even to the secretary of the company. Yeah, so with respect to the for certain members, like just to give you an example of the present webinar, certain logins are there with the team, R&D team and the technical team, and one login is given to Rachit ji and one login is given to me, and the separate login for the members. So that could be the same case with respect to the annual general meeting or the extraordinary general meetings for the company. That could be the case. Separate logins can be provided. Yeah, joining and closing of the meeting, they have said that 15 minutes before the meeting will be open and after the meeting it should be there. In certain cases, they keep it for a line for members to participate. Facility of remote e-voting. This provision, anything e-voting, the MCA has not touched upon anything to the e-voting. So the e-voting provisions, compliance, voting pattern and everything remains the same. There is no change for that. There is one corresponding provision that they have provided is that if there is a shareholder who has e-voted for a particular resolution before the meeting is conducted or through remote e-voting, then there would be a specific means he cannot vote in the general meeting which actually takes place. This even takes place in the general meetings that are conducted in person or a physical general meeting, that a person or a shareholder is voted through remote e-voting. He will not be allowed to vote in, you can say, in meeting itself. So then, but from the perspective of the chairman and the company secretary of the company and the scrutinizer, we need to ensure that aspect, that there is no double voting or there is no voting by one or two times in the general meeting. That is one aspect. Now, coming to the point with respect to quorum, there is a specific provision under the Companies Act with respect to quorum under section 103 of the Companies Act, which says about the quorum for the meeting. So unless otherwise the articles of the company provide for a larger number, in case of public company, they have mentioned 5 members, 15 members and 30 members. So basically anything about section 103, there is no sorry. So anything about the quorum, there is nothing changes for the company. However, there is one question from two chartered accountants and company secretaries, that whether the quorum should be through the meeting. In my view, yes, the quorum should be throughout the meeting, but you have to ensure the compliance provision in the article of association if there are any, or if there is a specific provision in the secretary standards. But quorum throughout the meeting would be required. For certain companies, this could be difficult, but that is now, you can say, the challenge of that particular company. So we have to ensure that and the presence of the members, that at least requisite number of members are present throughout the meeting. And one interesting aspect is that company and the service provider is aware of who is present and they are present. Like, to give you an example of the present webinar, that I logged out for just 2 minutes because of technical reasons, then this will be obviously recorded by the technical team of Taxman, and same would be the case with respect to the general meeting. So there is a trail of who are attending and who are not attending, available with the company or the service provider. So by that way, we can ensure the compliance of the requisite number of members present at the meeting. Proxy is not applicable, and therefore we need not have a specific provision. The proxy provisions are not applicable, and therefore we need not provide anything, proxy form or any other document for it. However, there is a specific provision which says that corporate representatives can attend under section 112 and 113 of the Companies Act. So company secretary or the chairman shall ensure that they are specifically receiving these authorized representation resolution or a letter from the shareholders, corporate shareholder of the company. But proxy is not to be considered. Coming to the next slide, there are a few points actually. Just before we conclude, actually there is one more slide. I will maybe share the content later. But this is what this slide, the present slide, which slide number 15, is all about. What is to be done in the meeting. But there are certain points with respect to what is to be done after the meeting. So there are some post-meeting compliances, or during the meeting there are certain compliances. I will be specifically referring to that. So there is one point with respect to statutory registers. That statutory register, there is a provision in the MCA circular that statutory registers be kept open for inspection, even in the electronic mode. Now there are obviously some security reasons for the company that they may not provide, but if at all the company is required to have decided to provide, then they can provide it. Probably they may upload it where the on the system through which they are providing the e-voting, or they may provide it from the last AGM to the present AGM that they provide, or some you can say in a login manner that they can provide. It is a very wide thing that they may provide it on the website of the company, but consider the confidentiality or the security reason, that could not be the case for all the companies. That is one aspect with respect to statutory registers. So though MC has mandated this aspect about the registers under with respect to the disclosure of interest and contracts in the director interested, or with respect to the register of directors and KMP, that is a very crucial aspect and a very important aspect to be addressed for this. So, MCA circular says mandatory to be done through electronic mode. Companies will be required to take certain steps about the security as well. Then there is one aspect that whether copies of the annual report, physical copies of the annual report are to be sold. Yes, company may do that after the lockdown, not just lockdown, but the situation in India is back to normal. So they may provide a copy if at all is asked by the shareholder. Then there is one point with respect to the filing of e-form. They have said that for all resolutions, the e-form shall be filed. So all resolutions that are passed, the company to now in which form, that is not provided, and also they have said about the 60 days criteria. Now there is no specific form for filing, means there is no specific form prescribed for filing so it can be done through MGT14, but MGT14 e-form MGT14 is to be filed with, means as per the MCA system also it allows to be filed within 30 days from the passing of resolution. So effective compliance of this particular you can say provision we need to ensure. Generally it can be MGT14 or GNL2 that it can file. Now one more practical aspect, because there is a provision about transcript of the general meeting. So it says recording the transcript and uploading the transcript. And there are few concerns whether you need to put the summary of the transcript. So basically when it says transcript, it says really about the video conferencing, the video that is actually you can say recorded by the company. So the question for few professionals and companies is that whether you upload the transcript or you upload the summary. Now there is a specific provision which says about uploading the transcript, nothing about summaries. We have to ensure that the entire transcript is uploaded. Another question is about for how many days the transcript is uploaded, because should it be uploaded for a period of say 1 year or 30 days? In my view, the conclusive evidence that the meeting has been conducted, there is a specific provision, you can say about minutes of the meeting. So till the time the meeting are prepared, finalized and signed, it can be uploaded on the website. After the minutes are you can say signed, then the company may. However, what I'm saying is my personal view. There is nothing in the MCA circular, but my personal view is through the reading the provisions of the Companies Act and the circular which is there. So and only minutes have got a greater sanctity, and therefore in that from that perspective can be uploaded for a further point of time only. However, if we see the transcript for the we can say for how much time we keep board meeting transcript available, it is up to the company of the audit. Obviously that is for board meeting and we are discussing for the general meeting, so there could be a different interpretation in view. Yeah, there is one aspect with respect to the Q&A in the VC meeting, because this is very crucial from the perspective of shareholders, which Rachit ji has rightly touched upon, that how can shareholders ask questions. So yes, we can send questions in advance, and there is a specific provision in the MCA circular that the questions can be asked concurrently. Concurrently in the event during the meeting, it is something like today's webinar, where in the chat box quite a few participants can ask the question, and in a similar way it can take place in the general meeting. So that could be the aspect. However, there is no restriction or there is always a provision where the companies can ask questions in advance. So that is one very important point. In my view, at least listed companies and certain public companies where there is a dispersed shareholding, in that case, I feel that the companies that the company replies or answers to certain queries raised by the shareholders. So that is to be complied, because in a general meeting in person, generally a provision is given to all the shareholders to ask, and nobody is restricted. So we need to bring some features of the general meeting in person to the general meeting through video conference. Then there is one aspect with respect to, I think broadly I have touched upon. So I had just noted down few points for the practical concerns which the participants may have. We can discuss questions now. Hello.
Okay. Thank you, Gauravji, for your absolute awesome presentation. And we have a lot of questions. Rachit has been answering them through the chat.
Yeah.
So Swati has a question: can we hold AGM out of India if member is out of India?
Yeah. So that's what I feel that since there will be no specific venue, he can be connected electronically. So we can have a means. In my view, there would be no specific venue for the meeting, so he can attend through a different manner or a mode or a different country.
Got it. Awesome. So guys, I hope all of you are able to download this presentation from your handout section. Okay, Gaurav and Rachit, we have a few more questions. So physical ballot papers for voting.
Yeah. Physical, yes. Okay. Mr. Mukesh has asked that physical ballot paper. No, there will be no physical ballot paper, sir. But I would like to touch upon one more important point about the role of scrutinizer, because there is a specific provision in the rules about the scrutinizer's report, and there is one provision which says about Rule 21, the manner in which the you can say the scrutinizer should present. So there would be certain changes in the scrutiny report, and therefore that needs to be changed. That is what the specific MGT form, the MGT 13. So there would be certain changes in that. So that is one aspect. Yeah, Mr. Harshvardhan has asked about what will it be the venue from where the recording is going on? Yes, may be considered. That may be considered as the deemed venue for the meeting. But when we say actually venue, something like a physical presence, so probably that would not be the case. So we may consider that as a place of recording. Shilpa ma'am has asked about how we show the statutory registers to members. Yeah, that is one way technical and you can say a challenge that we have. I feel that at one end we have to comply with the MCA circular, and the other side we have to ensure the technical aspect or the security aspect. So that would be should be taken care. We may upload it, but it should be subject to the it would be subject to the provisions of the security concern. So maybe a login ID may be provided, or some measures should be taken. Sridhar ji has asked about kindly elaborate more on the quorum, minimum number of members required. Yeah, so that would be you can say that would be one concern which would be there. That same provision is there under 103 that we have to comply. So I view quorum should be throughout the meeting. Section 103 shall be complied. There is no exemption from that compliance provision. Can I take few more questions? Is it fine?
Sure, Gaurav, please go ahead.
Yeah, Lakshmi R has asked a question. A company conducting a company conducting the EGM or postal ballot after 30th June compliance. Yes, if there is a specific timeline which the MCA circular has provided, then they may be extended. But I think your question may be answered if MCA provides an extension for that particular purpose. So, considering the present situation, certain circulars have been issued and exemption has been provided till a particular point of time. If situation in our country of COVID-19 is not improved, but I just hope that doesn't happen. then probably MCA may extend that. May extend it. Rakesh Bhargav sir has asked a question: if some details in respect of agenda for EGM, is it must to provide the details to the shareholder with agreement? Company will appoint new auditors, fragile vacancy. Can shareholder ask for complete details of new auditors? Yes, shareholders may ask, and probably even the company would be providing it in the explanatory statement about the new auditor. I don't think that could be the concern. Sir, is there any question that I have said?
Gaurav, I think you have covered most of our questions. Thank you for your patience and answering all the questions patiently. We have been getting a lot of thanks from the audience also. So there is another question like, what are the penalties if AGM to be held? Have you taken this?
No. So basically, yeah, the penal provisions is one act because there is no specific provision in the circuit about penal provision. So that could be one, but whatever penal provision under section from in that chapter, section 96 to 122, that could be penal provisions if at all the company doesn't provide. I'll just take one or two questions because there are few questions about private companies. Is it fine?
Sure. We can take another 2 minutes.
Yeah. It is necessary to file MGT 14 to the ROC by private limited company. Yeah. Now, if we see this circular, it says about 60 days that we have to file the e-form for all the resolutions that have been passed. Now, specifically in relation to this, MGT 14 is exempted for private companies by 5th June notification. 5th June 15 notification is by MCA. Now, since there is a specific compliance under the present circular of the generating through video conference, in my view, the company needs to apply with this particular aspect. Means I hope Chandrasekhar sir is asking only about a particular point, and yes, means specifically in relation to MGT 14. If a shareholder doesn't have email ID, should the notice how should notice be sent? Now, this is one very critical aspect. Probably in that case, the company may serve it in a physical mode if at all it is possible. But specifically in relation to if email ID is not created, then company should also ensure requisite number of shareholder email ID is registered. That is half of the total number and 75% of voting rights.
Okay, thank you, Gauravji. Thank you for all your questions. So, audience, please post your further questions to sales@taxman.com. Our R&D team will be happy to coordinate and answer all your queries. Hope all of you have received the handout as a PPT as a handout. Thank you all for attending. You'll also receive a recording of this. Also, another note, so Taxman Bookstore, I think you're already aware that we have launched most of our publications, finance publications. Books ordered from Taxman Store now come with alcohol-based sanitizing wipes to ensure the safety of your customers. Please go through taxman.com and see if you can order books as per your requirements. And thank you, Gaurav and Rachit, for your time today.
Thank you, Savina.
Okay.